This is the Franchise Consultant Podcast. Each Monday, we release a new episode hosted by Adam Goldman. Adam has over 10 years of franchising experience, and he's worked hard to realize his dreams by being his own boss. His experience will help you to become a better business owner and franchisee so that you can live your best life and control your destiny. This is the Franchise Consultant Podcast, and this is Adam Goldman.
Welcome to another edition of the Franchise Consultant Podcast. I'm here and have my friend Jeff Wheelock from Dickinson and Wheelock Law Firm. Thank you. Welcome to the show, Jeff.
Thanks for having me today, Adam.
So if you could please tell me and our listeners a little bit more about what your firm does.
My part of the firm handles, these days, mostly franchise-type matters. We represent franchisees. We represent franchisors. Some of it is litigation. Some of it is creating the FDD if you're the franchisor to sell franchises. Some of it is to review and understand and negotiate the FDD and the franchise agreement if you're the franchisee. Unfortunately, sometimes things go badly, and so there's a need for litigation or arbitration or some sort of dispute resolution. We handle that. And then on a happier note, sometimes people that are franchisees, they've developed an asset, they've developed a business, they want to sell their business, and so we help with the sale of the business after they've been in it for a while.
So you recently wrote an article about the 5 things to look for in a franchise agreement. Could you please comment on that?
Sure, and for the plug, you can go to texasfranchiseattorney.blog, and the whole article is there. But what we did is we created a little bit of an article of things for franchisees to be aware of. The first one is that, of course, it's negotiable. And some of the franchisors will either say directly or allude to an idea that the franchise agreement is fixed in stone and it is just simply not negotiable, and they're not even willing to consider anything for as far as changes. And I'll tell you, I find that to rarely be the case. My personal experience is a lot of times the franchisors will consider changes. That being said, they're not going to make some of the changes that are most obvious, and maybe some of your clients think that they're going to get. Most commonly, the franchisor is not going to change the amount of the initial fee. Most commonly, they are not going to change the amount of the royalty rate, or that the royalty is based on gross revenues. People will say, well, then, gosh, what does that leave? And my response is, well, the other 50 pages of the contract. So there is a lot. Some of them are issues that are geared toward events of success. Let's maximize your success in the event that we're going to, be involved in this thing. Things like, when I transfer it, I'd like to have the transfer fee reduced. Transfer fee is reduced in theory. If you're able to do that, then that is more money into the pocket of the seller. Some of them are going to be geared a little bit more toward things don't work out very well. And that's going to, I'll get into that in a little bit of another one of the points. Another issue for people to consider is territory. If you're involved in real estate, everybody always says location, location, location. If you're involved in the world of being a franchisee, it's territory, territory, territory. And to some degree, it's the location of the territory, but in my mind, it's a little bit more about the size of the territory. And so you want to make sure, or you'd like to work on getting, as big a territory as possible. And the reason behind this, of course, is that you don't want to be competing with your own brand, in an area that is too close to you. You don't want another franchisee who's offering the same services, the same goods under the same brand being too close to you. This is America. We can't keep somebody from having a similar business moving in across the street, but you want to keep another one of the franchisees having the same brand moving in too close. Another concept, and I'm just talking. If you want to break up the...
This is good. This is great.
Another one is be aware, franchisees, that when you are reading through the FDD and you're reading through the franchise agreement, some of the terms may not mean what you think they mean. Some of the terms are, it's not so much that you're trying to be sneaky. The lawyer's not trying to be sneaky. It's just that the terms may not have some of the common sense meaning that you think that they're going to mean. And I wrote this in the article. One of the examples of that has to do with post-termination obligations. If this doesn't work out for you, franchisee, then you are likely to be terminated, whether it is your fault or whether it's not your fault. If it wound up being a bad location, that's not really your fault. If you're not open enough, that is your fault. Some of these are going to be your fault, some of them are not going to be your fault. But nevertheless, you're still going to be terminated. Well, the franchise agreement includes some provisions about what happens to you in the event that you are terminated. What are your obligations? And some of those obligations make a lot of sense and they're fair. Things like you have to stop using the trademark. Of course you have to stop using the trademark if you're not a franchisee anymore. You have to stop using their confidential information. You're not allowed to be in competition with them. A lot of these make a lot of sense and are fair, frankly. But then there is the all sums due. And so the franchise agreement very commonly will say, and you have to pay all sums due. I think that regular human beings that aren't franchise lawyers probably think that all sums due means I have to pay all of the amounts of money that were due prior to the time of termination. Some franchisors think that, but most of them don't. Most franchisors interpret that clause to mean all of the money that you would have had to pay during the remainder of the first term or the full term of your franchise agreement. So let me say that a little bit differently. I'm in the fourth year of my franchise agreement. My franchise agreement is for 10 years. Whether it's my fault or whether it's not my fault, the franchise agreement gets terminated. I still have 6 years left on the franchise agreement, and the franchisor's franchise agreement probably is written in such a way that you still owe them for 6 more years of royalties and advertising fees and technology fees and computer fees and convention fees, et cetera, et cetera. And so a lot of people don't really realize that. So, be careful. That word may not mean what you think it means from Princess Bride. And then the last one that I was going to put, that I put in the article, and now I made it so nobody has to see the article, is move at your own pace. And I will tell you, Adam, I'm really pleased and impressed. This is a little pitch to you. A lot of franchise coaches or franchise consultants or franchise brokers actively discourage their clients from being involved with an attorney, whether it be a franchise attorney or a non-franchise attorney. And I think the idea is that they don't want anything to stand in the way of the client signing off on the deal. And I think good and reputable franchise consultants are going to want their clients to talk to somebody like me, not just a random lawyer, not somebody who does criminal law, not somebody who even just does contracts, a real life franchise attorney. And I think that serves everybody. I think it certainly serves the client because they understand the deal that they're getting into, if nothing else. I think it serves you well too, because you want your clients to be involved in a deal that they understand and they are, appreciative of what the deal really is. So again, that was, a little kudos to you for having me on. Not only are you encouraging people, but you're actually going to, sort of give somebody like me a chance to talk a little bit. So that's good. And so my last point really was move at your own pace. The franchise disclosure document says the Federal Trade Commission, the franchisee has to have that for at least 14 days before they're allowed to sign. That doesn't mean that you have to sign on the 15th day. It just means that you can't sign before the 15th day. Franchisees, you need to work with people like Adam who are going to, help you with the process, but you don't want to work with people that are going to try to speed you through the process. Let's hurry and get you to the 15th day, and by God, you have to sign. I was talking to a fellow yesterday, and he says, well, I want to come in and talk to you, Jeff, but I have to sign on Friday. And I said, why do you have to sign on Friday? Oh, because then that's the 15th day. And I said, no, that's just the first day that you can sign. That doesn't mean that's the day you have to sign. I'm not telling people to slow down as, a negotiation tactic, but this is a big investment. And, don't you want to understand the deal and don't you want to feel comfortable? And if you're not quite ready and you still need to talk to a few more people, or you still need to visit with an attorney, or you still want to talk to Adam a little bit more, that's what you need to do. You, the franchisee, are the hot commodity. The reality is it's hard to sell franchises if you're the franchisor. They're glad to have found you. So Don't let them convince you that, by God, if you don't sign today, the little old lady from Pasadena is going to come in and sign and take over the territory. That could be true. I find that to be rarely true. Don't go slow just for the sake of going slow, but this is your deal. Sign it when you feel like you are ready to sign it. This is a long-term commitment. You're probably going to be involved with this franchise, 10, 15, 20 years. Taking a few extra days to make sure that you have all of your ducks, lined up and you feel good about it. That's what I would want to do.
That sounds like great advice, Jeff. And just to follow up on what you were talking about with things being negotiable, have you seen any COVID-related concessions from franchisors to prospective franchisees?
A little bit. I'm seeing sign up now and you don't actually have to open quite as soon. One of them that I recently saw said it was kind of a tutoring type of business. And we don't really, it says the franchisor, we kind of acknowledge that we don't really know how this is going to, our industry or our business is going to be affected. So we'll give you some extra time to open, and that may be good, so that's one of them. That's kind of the biggest one that I'm seeing right now. I'm not seeing a lot of COVID specific terms that are being put in right now. Now, that could be the case. That may develop and evolve a little bit, over the next few months. But for right now, I'm not seeing too much more than just the delays on opening.
So how many years have you been a franchise attorney for?
I have been licensed since 1991, so a million years. And I've been practicing franchise stuff since probably 1997 or 1998. So let's see. If I were good at math, I would have done something useful with my life instead of be a lawyer. So I guess that's about 22 years doing franchise things.
What is the worst one-sided franchise disclosure document that you've ever seen?
Oh, man, that's a good one. I don't want to say it by name because I don't want to get in any sort of trouble.
I get it.
But the ones that I always find to be a little curious are every once in a while I will see a franchise disclosure document for a franchise system that doesn't actually even have any stores open yet. And as crazy as that sounds, I've seen that. They don't even have a company-owned store that's been running for a while. They've got no stores. And so the very first franchisee is going to be the very first person who's ever had one of these businesses up and running under this name at all. And gosh, that's not really a franchise system as far as I'm concerned. So I think, I don't know if that one was more lopsided, but more hard to believe that somebody was, going to do. I guess it could work out. That one didn't work out. I've seen a couple of them and they don't work out, but I'm not saying it couldn't, but that seems like you're sort of buying a pig in a poke.
What about on the flip side, the best agreement you've seen for a potential franchisee?
One of the ones that, so since I'm going to speak positively of one, and this is not my client, the Sylvan Learning Center, just as a good example. I think they are well established. They've been around for a pretty long time. They've got a lot of franchisees. I'm not going to tell you that the franchise agreement is pro-franchisee, but I think that it's pretty fair and reasonable. It's got, and it's not even things like, the amount that's being charged. I mean, the amount that's being charged by a lot of franchisors is pretty standard. I'm not telling you that the Sylvan deal is way, way cheaper than any of the other deals, but I think that, just sort of the reasonableness and what it is that Sylvan is promising is been put in writing. I think that's a good example. They're not the only ones. That's just one that pops to the top of my head as being a good FDD with the franchise agreement.
Could you comment a little bit about your impression of item 7 and item 19? Because with my candidates, we talk about those items a lot.
Well, especially with regard to item 19, the financial performance representations, it's still, I think, an area of the law that hasn't really been solidified yet. I think the Federal Trade Commission is still trying to figure out exactly what is the right balance with regard to a franchisor making some sort of, not even representations, providing some information with regard to earnings and not going over, on the other side and making false promises. The way that the Federal Trade Commission rule is written right now is that the franchisor effectively can give out any sort of information about earnings that is objectively verifiable. That's not the official standard, but that's kind of the gist of it. And so therefore, you can give past information because that is objectively verifiable. You could never, ever, ever give out any sort of estimation about how somebody is going to do in the future because you can't verify the future. This is the tension, or this item 19 is a great example of the tension that exists between the salespeople and the lawyers. The salespeople's position is, how in the world are we going to be able to sell something if the franchisee doesn't have any sort of expectation about how much money they're going to make? It's a very legitimate concern. Salespeople, I get it. The lawyers across the country are all terrified of the Federal Trade Commission, and they don't want ever to make a representation or a statement that could possibly come back and bite their client in the bottom in the future. So some franchisors, a lot of franchisors, will basically include a very short statement that simply says, we're not obligated to give any information, and so therefore we're not going to, which really seems like a poke in the eye, but it's because the lawyers figure if we don't give out any information, we can't get in trouble. So if you see that, franchisees, don't take that as some sort of, we're trying to hide the ball. That's just kind of the lawyers trying to look out for the client. Some franchisors will, in their FDD, will include some information. And when you go through the information in an FDD that provides a lot of financial information, look at what it includes, but then sort of scrutinize it as to what it doesn't include. Yes, here are the revenues. Revenues are kind of relevant, but if you don't have expenses, then who cares? I had $1 billion in revenues. Yeah, I had $1 billion in revenues, but I had $2 billion in expenses. That's not really a good business to be involved in. So revenues by itself are not really the end of the analysis. Sometimes they'll say, they'll give you quartiles. This is what the top quartile does. This is what the median 50% does. This is what the bottom does. A lot of times the franchisees, everybody wants to be in the top. Everybody figures, I'm going to be in the top 10%. And that's, great. That's your goal. You want to be in the top 10%. But on average, you will be average. And so when you're running some of your numbers, maybe you need to look at the median numbers and the average numbers. But I think most importantly is the information that you might be getting in a federal franchise disclosure document, in an item 19, shouldn't be the end of your analysis. Yes, that's a really good starting point. Yes, that's going to give you some information. But what you really need to do is you must go out and talk to some of the other franchisees. And you need to ask them, how are you doing? What are your revenues as compared to your expenses? How long did it take you to get to this, place? If they're now in the 8th year and they're doing great, that's great. But if it took them 8 full years to get to great, then you need to know that. If for no other reason, you need to have reasonable expectations of how your business is going to do. So,
what about the item 7?
With regard to which part of it are you concerned about?
Of the expenses.
I think that, again, this is the type of deal that you just need to go and visit with the franchisees. It's again, this is the tension between the sales guys and the lawyers. The lawyer's position is we need to give estimated initial investment that will never be exceeded. And so we're going to create this huge range, and so your estimated initial investment for the first 3 months is going to be somewhere between $100,000 and $14 million. Says the lawyers, because if we do that, we'll never get in trouble because no one will ever exceed $14 million. And the sales guys say, if we put that in, everybody's going to think that they might have to spend $14 million. That's an exaggeration, but again, this is the tension. So the lawyers, when they're writing this, always want the client to guess really, really high on the high end. So ultimately, it's been my experience that franchisors try to give good numbers. They may create a little bit bigger range because their lawyers don't want them to get in trouble. But it's been my experience that franchisors really do give numbers that they believe are fair and reasonable. I always tell my clients that you need to go out and you need to visit with the other franchisees. Not so much that you're trying to play gotcha with the franchisor. I'm usually very, very surprised if I ever hear, these numbers are way off. But I would want to know if the range, and so now I won't use the crazy $14 million number, but if the range of an estimated initial investment is somewhere between $250,000 and $750,000, well, that's a pretty big range. If you took that to the bank to go borrow money, the bank would tell you, go try again. Being off by a multiple of 3 isn't really a very reasonable forecast of how much your estimated initial investment is going to be, certainly for the purposes of borrowing money from us, the bank. So if for no other reason, I would want to go out as the franchisee and the potential franchisee and talk to a bunch of, not 1 or 2 or even 3 or 5, a bunch of the other franchisees and say, how much did it really cost? Again, not so much to play gotcha as much as is I want to have a more reasonable expectation of what my costs are going to be. And when you're going out and visiting, go out and try to visit with people that are in similar markets. I'm in Houston. It would be great to talk to the Houston people, but I'll take the Dallas people. I'll even take the Atlanta people. Maybe I want to talk to people that are in southern-ish type large cities. The guy who is in Bangor, Maine, he's a good guy and he really is part of the system, but his experience may not be as directly relevant to what my experience is going to be. And so there are more similar franchisees to call.
Have you ever seen a franchisor that claims that expenses are Y, right? Like really, really low, but they actually end up being really, really high in practice?
Yes, I do. And that is sometimes a basis for getting the franchisee out of the system. That is a violation of the Federal Trade Commission rules. It winds up being a violation through a series of jumps of some Texas rules. That's what I was talking about, that the franchisor's attorneys desperately don't want, because now you have misrepresented, franchisor, the expectation of how much money. And so if I wind up, if the high end of the, the estimate is $500,000 and my costs wind up being $500,001, is that a misrepresentation? Now, maybe it's a misrepresentation, but who cares? If it winds up being, $1 million, that's a real problem. And that is exactly the kind of thing that the Federal Trade Commission established the FTC rule for in the first place. They want people to have a reasonable expectation of what it is that they're really getting into. If the franchisor has misrepresented that, it's only going to cost you $500,000, but you wind up spending $1 million, not because you overspent or you were crazy, and you did a bunch of foolish things, but mostly you were just following along and none of these original numbers were close. Now you're in violation, certainly, of the spirit of an FDD in the first place. It's supposed to give you some reasonable information to base your decision upon. The franchisor is not allowed to lie. What's the point of a disclosure document if it contains a bunch of lies? So yes, I see that sometimes. I especially see that. I more often see that with a relatively new franchisor because I don't think that they're necessarily trying to be sinister and there's not evil in their hearts, but they just didn't know. And so, I do see that some.
So Jeff, if someone wants to get a hold of you, what's the best way to reach you?
The easiest thing to remember is texasfranchiseattorney.com, and you can look that up, or you can just call up. The name of the law firm is Dickinson and Wheelock, and you can just call me up, 713-722-8118, Jeff Wheelock. The last thing that I do want to throw in a little bit, and toward the end, let me know. But my last bit of unsolicited advice that I often give to people that call me as a franchisee especially is make sure that you go and you talk to a franchise attorney. I'm not the only franchise attorney, but there aren't very many of us. And what you're really looking for, potential franchisee, is you want somebody to review this document who has experience having seen hopefully hundreds of these. If you go to the criminal lawyer, he probably doesn't even look at contracts. If you go to a contract lawyer, he doesn't really have as much experience with the ins and the outs, and he doesn't really know how some of these terms are going to play out. And he certainly doesn't have a very good feel for what's negotiable and standard and not standard and not negotiable. And so my recommendation is to go to somebody like me, hopefully me, but if not me, somebody like me who really has that experience. So whoever you wind up using, potential franchisee, make sure that this lawyer convinces you that this really is what they do for a living, because that's what you, potential franchisee, are looking for in an attorney.
And Jeff, one final question. Do you work only in Texas, or do you have other states that you work in as well with candidates?
I am licensed in the state of Texas, but I help clients that are franchisees and franchisors from the contractual standpoint all over the country. So if you are a potential franchisee and you are in Florida, you can certainly call me and I can certainly help somebody, help you along. I deal with people not only throughout the country. I was talking to franchisees within the last year in Saudi Arabia, Afghanistan, and Germany. So I can certainly help you all over the country.
Do you do E2 visas as well?
I don't. I know what I don't know. And so if you need some information with regard to that, I could probably direct you to the right person that does immigration law. But no, I don't directly involve myself in any sort of immigration matters.
Well, Jeff, so great to see you again today. And thank you so much for your time.
Adam, thanks a lot.
Thanks for listening to this episode of the Franchise Consultant Podcast. We hope you've gotten some useful and practical information from this show. And if you enjoyed this episode, please subscribe, give us a rating, and leave a comment on iTunes or wherever you listen to your podcasts. Explore great resources on our website, franchisecoach.net. And if you'd like more content regularly, follow us on LinkedIn or Facebook. And hey, be sure to listen next time so you're able to realize your dreams.